But while we're getting started, I'm going to go ahead and just start this off by telling everyone thank you for joining us. I'm sure that more people will start to come in as time progresses a little bit here. So normally I start a minute or two after the hour just to give people a minute to log in. If you're new to our webinars, the way that we do it all the time is at the top of the screen. There's a Q&A button. If you have any questions, and you're also not restricted to the topics that we're talking about, but if you have any questions that you want to know from Jeremy or I, then just put it in the Q&A there. That's usually my favorite part of the entire thing. So use the Q&A as we go throughout, so you don't just have to think of questions at the end. We will answer them at the end, but as you think of questions while we're talking, hit the Q&A button and then type whatever your question might be into it. And then I guess just as an introduction, I am fortunate enough to have Jeremy on this webinar with me. I'm usually just talking to myself, which I do all day, and so it's really nice to be able to have Jeremy on here. Jeremy's a new attorney at our firm, but not a new attorney. In fact, I've known Jeremy for a while now. Before Jeremy was working with us, he was working at the Department of Labor, litigating cases, and I must say it's much better to have him on this side than it was the other side. So it's great to have him. And then yeah, Jeremy, I don't know if you want to give just a little bit of background on yourself, but I think that people would love to hear it.
Yeah, absolutely, and vice versa. We've been to battle, Kyle and I. We've been to Balka. I was at SOL, so I was in the solicitor's office with Department of Labor, and I was working in appellate cases. Last night, I had the good fortune to read one of the decisions on a debarment action actually, that came down that preceded my working here at Farmer Law. So it was kind of a good throwback, it was interesting for me to look at the work that's now being adjudicated and the decisions are being made. But I will say, Kyle was a formidable opponent, and so I'm happy also to be on this side.
Awesome. Okay, so today what we're going to talk about, we're going to talk, and we've got a lot of content we could cover here, so we will gauge mine and Jeremy's ability to manage time, which honestly Jeremy's is probably better than mine. So, but we're going to talk first about the incoming administration, just some immigration changes to expect. We could have separated this into 3 different webinars just with how much content there is. And so, and in fact, we might do a subsequent one, I don't know, with similar topics just because there is so much to cover. But we're going to talk about that. Then we're going to go through the new H-2 or the H-2 Modernization rule that came down from USCIS, and that is actually effective day after tomorrow. And just some of the highlights from that rule, the implications, that some of the things that you should be thinking about, and then and yeah. So feel free to ask any questions as they come up. I will share the screen here in just a sec. It's going to take a second for this to pull up. Great. Let's see. One sec. My email likes to make sure that I'm not getting got by our own Omar. All right. Here we go. Oh, yeah. Now we're with all grease. There we go. All right. Great. All right. So this is the part that I kind of already talked through. And so again, we're going to go through these different sections, and then at the end, we'll do the Q&A. So please ask your questions as we go on, and we'll get to those questions at the end. Y'all got our intros. All right. I guess here, Jeremy, you want to?
Yeah, I guess I can take it away from here. So good morning, and thank you for all being here. Thank you for Kyle to invite me to this webinar, and thank you for Omar for putting the slideshow together. Yeah, so we're here to speak a little bit about what to expect from the incoming administration as it pertains to immigration policy and law. This could be, as Kyle just indicated, a very lengthy conversation. We'll try to keep it to some sort of discretionary mean. I don't think we need to talk that long. I'll just go through some of the main highlights. Obviously, immigration was forefront in the 2024 presidential election, particularly from the president-elect. And so the administration, I do believe, is going to come fast and furious, at least in the manner in which they can do, according to the law, looking towards immigration as one of their major topics. So what can we expect, right? That's going to be what I'm going to be discussing over the next few slides. Some of these changes will probably be done. In fact, there's a good indication that many of them will be done through executive order, while others are going to take regulatory revisions in order to see it through. So those are administered by the APA. They take notice and comment requirements. There needs to be a publication in the Federal Register. Those needed to be worked out with the agencies in order to promulgate those regulations, and we can get into that a little bit later. Depending on how expansive the administration wants to go, and depending on the way that um, right now it looks like the branches of government are fairly fully stacked in favor of the Republican administration, right? So we've got both houses of Congress, we've got the presidency, of course, all the executive authority that comes with that, as well as the major branches. So if you go through a lot of the district courts, a lot of the appeals courts, and of course the Supreme Court, everything seems to be pointing to what could be fairly significant changes, not only in regulations, but statutory authority as well. And so we will see. There's no crystal ball, right? There's no way to fully predict, but when we look back upon what the first Trump administration attempted to do, there are a lot of good indicators as to what this administration will attempt to do as well. So what I want to go over then is just some of the broader policy proposals we might expect from the incoming administration. Maybe briefly touch on potential changes to the H-2A program, which I think is important to a lot of people on this call, and then use the H-2A program as I go through some of the larger programmatic shifts that we might expect as an example of employer-based regulatory changes that may be pertinent to anybody that's on this call. And as Kyle's indicated, I think, please feel free to put any questions in the chat. If there are things that come up as part of this presentation, hopefully we can circle back and address them. But I will go ahead and get started then. The first, and this should be no surprise to anyone who watches the news, there are likely to be a lot of changes and specific attention to border security. So I won't go into a lot of detail here because any proposals from this new administration have not been made public. But as you can probably see from the slide, some of the key aspects for border security are going to focus on physical barriers. So I don't think there's anyone that lives on Earth that has not heard about the border wall. There's potential that will be expanded. There could be money that's put into that. That's CBP budget. That's stuff that will come through regulatory, but mostly congressional authority, depending on, budgetary outlays. There can also be enhanced border surveillance, right? So there's a lot of things that have been proposed with drones, with agents on the border, with some digital intelligence that allows us to understand where and when people are coming into the United States. That again is going to take congressional authority for the budget outlays, but those are the things that we can. I don't think it would be any surprise to anybody if the new administration is not looking towards those. As well as that, you have detention facilities, right? So there was a lot of bad press. I think nobody on this call is unfamiliar with some of the detention facility press that came out of the first administration that somewhat went away, but it's not going to be something that can be if the border security is going to be the issue that it looks like it will be. Rest assured, there will be news about detention facilities, and we can probably expect that there will be an expansion of those facilities, given a lot of the priorities that the administration has already forecasted. So I'll leave that alone. Border security is its own hot button topic. Like I said, there's not a lot that we know yet. We can only sort of, it's circumspect as to the way that a lot of these things will come down. The next of these is the reinstatement of the Remain in Mexico policy. So I don't know if anybody remembers, but there were a series of protocols, the first of which came out in 2019, which were the migrant protection protocols that the first Trump administration promulgated. Those basically had the effect of making sure that anybody that was seeking generally asylum, but were the foreign nationals that were trying to enter the United States, particularly through Mexico, but from a lot of the southern border, coming through South America, Central America into Mexico, regardless of the status that they were seeking, they were to be, if they were able to cross the border into the United States, they would be returned to Mexico for the duration of their immigration proceedings. And the way that that worked under the MPP was that foreign nationals would then go back to Mexico. They would be returned to Mexico, which was generally the last place before their entry into the United States. And they would have to stay there and wait for their appearance. They would be given notices for appearance to the immigration court. Once they received those notices, while remaining in Mexico, they could come into the United States, but only for that judicial adjudication, right? So the understanding is that the Trump administration is more than likely to try to work. Now, of course, there's a president in Mexico, there's President Sheinbaum. That's going to take cooperation between the incoming administration and the new administration in Mexico. There have been some flare-ups. I don't know if a lot of people have been watching the news, but renaming the Gulf of Mexico to potentially the Gulf of America has been a touchstone in that sphere. And so we'll have to see whether or not any cooperation between the new administration in Mexico and the incoming administration supports what was the MPP and a reinstatement of that policy. But no doubt, I would say, and again, this is just an opinion on my part, but I think if we're making projections, what we can expect, likely the incoming administration will look towards making sure foreign nationals are kept in Mexico, remain in Mexico, while any immigration, particularly asylum proceedings, are first initiated, and then working with the government of Mexico to ensure that only during the duration of their stay for the proceedings could they re-enter into the United States. After that, there's DACA. I feel like we always talk about DACA. DACA has been a kind of a flashpoint in terms of what people look at for immigration on the policy perspective for a long time. So, just as a refresher, DACA is the Deferred Action for Childhood Arrivals. This was first initiated through an executive order in 2012 by the Obama administration. What it does is it allows for foreign nationals to come into the United States who are children. So before their 16th birthday, they need to make sure that they have met particular guidelines. So no criminal record, et cetera, et cetera. Once they have met all of those guidelines, then action is deferred, right? Which means that they are not subject to deportation or removal proceedings. Initially, that was for 2 years, subject to renewal, and they were eligible for employment authorization documentation. In 2022, there was an attempt to initiate a final rule that would fortify that, basically locking it into effect, but that faced very steep litigation challenges. And under the incoming administration's first term, they supported a lot of efforts to end DACA. They thought that there was an overreach by the Obama administration in allowing for the order to happen itself. They thought that Congress should have been involved and that it needed a more permanent legislative solution. And so this all has got tied up in a lot of litigation. There was a Supreme Court ruling in 2020 in which it was attempted to block, and in fact, they did block the then Trump administration's efforts to end the program, but that was not a fully comprehensive opinion in terms of not allowing for litigation to continue. So DACA is certainly open to further challenges in the court. It's very vulnerable, and in fact, right now there is litigation. So there was a Texas District Court opinion that ruled that the DACA program was unlawful. What could and probably will transpire, if we're just sort of forecasting and reading the tea leaves, the Trump administration could definitely instruct the Justice Department not to continue to defend the program and curtail it in other aspects, limiting certain restrictions as to what entry requirements are. But ultimately, that could lead to DACA termination. And again, these are just like the big ticket items. This is what, we can, because the Trump administration coming in, President-elect Trump himself was not bashful and talking about what he intends to do on the immigration front. We've got a fair amount of data as to what we can look at, right? As to what we can expect. So the next of these are on the humanitarian protections front. Humanitarian protections, this is kind of a convoluted area, but initially in his first term, President Trump, he set the annual refugee admissions ceiling to basically its lowest ever, right? So in 2017, he set the bar so low that it was at 18,000. I'm sorry, 50,000 in 2017, but then 18,000 in 2020. Just as the pendulum swings, the Biden administration came in and changed that fairly dramatically, increasing the limit to 65,000 for the ceiling level in 2021. And then there were significant increases thereafter in 2022 and 2024. So just as sort of a juxtaposition of administrative policies, we can already see where the priorities are going to lie, right? So there's going to be I think in the incoming administration, an attempt to curtail quite a lot of the incoming foreign nationals wherever that is feasible. And so we'll get into a little bit later, as long as I don't ramble on too long, with how those things might happen, whether it's through executive order, whether it's through regulatory changes or through acts of Congress. But these are going to be the areas where, for those that are concerned with TSP, these are going to be pressure points. For those that think that there are too many people already being admitted, this is going to be a place where, TPS, temporary protective status, is likely, I think, to be cut back, trimmed. It's going to be a place where the administration is going to look towards budgetary savings and also look to all the countries that had been eligible for this program and to reevaluate. And so those those are sort of the big ticket items just in terms of the headlines. Now, what in brass tacks this means for employers, and I think a lot of people on this call are more interested in what it means to you. There is going to be, without a doubt, a more rigorous survey of the way in which foreign nationals come into the United States are employed. And one of the places where that is most relevant is with I-9 compliance. So just about, well, everybody in the United States has to comply with the I-9 requirements for those that are coming into the United States to verify identity and work authorization status. This is generally thought to be a pretty straightforward form for anybody that is in the space of working with onboarding or bringing new hires into a company. These compliance efforts seem to be more than adequate, right? They don't seem to be that cumbersome. It's a simple form. They need to, anybody that is hired, anybody, whether it's a US citizen or a foreign national, needs to show proof that they are eligible to work in the United States. However, believe it or not, often these very simple measures are not taken. And so if there are not adequate records of I-9s, then what we did see in the first term of the Trump administration was a very, very high-pitched volume of audits for I-9s. And so this is kind of where the rails meet the road, if you will, for immigration enforcement and employment in the United States. It's a very easy go-to for an administration that is going to be looking to enforce whether or not employers actually maintained what is required under the law for bringing foreign nationals and employing them in the United States. So Immigration and Customs Enforcement, that's only one of the agencies. They conducted more than 6,000 audits in 2019 under the previous Trump administration. They would have probably reached what was their goal of 15,000 audits in fiscal year 2020, except there was the pandemic, and so they didn't. But there were stated goals in mind for conducting audits and going in and reviewing employers' records. ICE does maintain authority to penalize businesses for any Form I-9 errors. These fines range from $300 per, about $300, close to $300 per violation, to as much as $28,000, just about, for more serious repeat infractions. So, if there's going to be a pressure point where the administration wants to ensure that employers are doing what they're supposed to do, I-9 compliance is going to be the soft underbelly, if you will, of finding whether or not employers are doing what they must. And so ICE can initiate audit requests, but so can the Department of Homeland Security, as well as Homeland Security investigations. The way that they go about this, they can appear on site, but they can also just do their audit requests through subpoenas. And in those subpoenas, they can require all the information from current and some former employees, which amounts to such things as passports, right? So as part and parcel of the compliance folder, any employee must have presented documents establishing their ability and right to work in the United States. Those records are supposed to be kept for 3 years, and they are things like passports, birth certificates, ICE, Homeland Security, and Homeland Security investigations can subpoena all of that information as well as the employer's payroll information. So, what does that really mean? That means that if employers are not aware of what the regulations and statutes entail with respect to I-9 compliance, they should probably think about this on their radar going into this administration, whether or not they think that they have operated under all of particular legal standards. The compliance itself can be problematic. And so the retention of documents, the way in which the documents are then given during any audit investigation, the way that they're explained, and the way that any of the I-9 compliance documents are produced is going to be an issue, I think, going forward. And these are not the audits are supposed to be, generally speaking, random, but if is reasonable suspicion of non-compliance, then ICE can certainly go in and take a look. And that's the same across the agencies. So I-9 compliance is going to be a big one. So what does this mean? Implications for employers? And I'm going to wrap it up as soon as I can to hand it off to Kyle, but there are certain implications going forward under the new administration that we can expect, right? So just to back up, in the short term, there's going to be a level of uncertainty as to what the new administration intends to do and how they intend to do it. We talked about border security. We just don't know, right? Like that's going to be a congressional allocation by and large and CBP. And the funding for that, it's not something that we can point to and say there's a straight trajectory. Like we know that this is going to happen in this way. That's one that is outside of, anybody that tells you that they know what's going to happen is probably wrong. We do know that border security is going to be one of the major underpinnings of this administration. They're going to want to look to it. It's going to be a trophy in terms of the way that they're able to present it to the media, because that was a platform agenda. And so there's no getting around the fact that that is going to be a major issue with this administration. And by issue, I don't necessarily mean morally right or wrong. It's going to be something that they pursue, and this administration is going to pursue it pretty heavily. But we can't really project. We don't know on that. In other avenues, what we can say, as I stated earlier, there's going to be immigration reform. Now, how is that done, right? That can be done through executive action, can be done through regulatory rulemaking, or the administration can lean on Congress to try and inspire them to take more substantial measures for long-term immigration reform that would take statutory reform. I don't think the latter of those is the most likely. immigration is a very slow moving beast. It's not something that, even in the best of times, if one perceives these to be the best of times, when you have both of the houses of Congress, the administrative um, levers of government, you have the Supreme Court, and you have the executive branch mostly aligned. Immigration is a complicated and very entrenched animal, and so it's not likely to be overhauled in one administration, quite honestly. And so what we're looking at then is regulatory rulemaking and executive action. So just as a brief overview of what those things entail, executive orders, they do have the binding force of law, right? And they come into effect immediately as of the date of signature. They don't require approval through Congress, and they can be subject to judicial review. So if, for instance, the Supreme Court says and has done, both in the previous administration, by which I mean the Trump administration, as well as in the current administration, which I mean the Biden administration, executive orders have been overruled and can, going forward, be struck down by purview of generally the Supreme Court. But what we're looking at is going to be probably a flurry of executive orders. They will be reviewed. They will probably come under scrutiny in terms of just how far they can go. There's almost nobody on this call that is unfamiliar with the ban on immigration as pertains to certain countries that may or may not have been more likely to foster environments for terrorism, right? And so that is one of sort of those things go up to the highest levels. They're looked at very, very with a lot. I think there's a lot of weight that goes into that from a Supreme Court review, but those sorts of things are probably not what we're going to look at in the incoming administration. The incoming administration is going to do what they know they can do in a more precise way, because they've already gone through it once. They've already jumped through the hoops. They kind of know what they can and cannot get away with, if you will, what can be enacted quickly. And we're not going to be looking at, I don't think, those sort of major challenges constitutionally in the next administration. Now, what they certainly can do, and I think what they will do, is that they're going to try to use the federal rulemaking power to change some of the regulations under the Administrative Procedure Act. Generally speaking, any substantive changes to federal rules they have to undergo notice and comment. They need to be published. They also need to be finally published after stakeholder input in the Federal Register. But we've already seen this done. We see this done in each administration. The Biden administration was very heavily focused on worker protections. And so there were a lot of rules that came out under DOL. And also just recently, as Kyle will speak to, under USCIS. And so I think what you're going to see, the big takeaway, if you will, of all of this is that you're going to see in the next administration a big swing from what was a very worker protected concentration to a much more employer focused concentration. And the way that that is undergone, I think, is going to be outside of the congressional avenue. It's going to happen by executive order and in the federal rulemaking process. And I'll just briefly touch on one example in H-2A, and then I'll hand it over to Kyle, who's more charismatic than I. and just sort of flesh out just a bit as to how this might look. So with H2A, and particularly as I was just talking about, the shift from worker protections to employer-focused rulemaking, a very good indicator of what we can expect is the H-2A rule that the Trump administration tried to promulgate just before they were leaving. So they were stepping out of office. They were literally handing over the keys to the White House to the Biden administration, and they were about to publish a final rule. That final rule was withdrawn by the Biden administration because it never officially published in the Federal Register. So, like, that's as close as you can kind of get to regulations just about being done without being done. But what the Trump administration tried to do was freeze the main wage rate under the H-2A guest worker program for 2 years. So that would have been huge, right? Like that would have, generally speaking, there's an annual increase in H-2A guest worker wages that's reassessed. And a freeze of 2 years would have locked it in at that time. We're talking about a time of, sort of COVID and coming out of COVID. The wages were already kind of depressed, if you will. That would have made a huge impact upon employers. And that would have decreased the payroll significantly for employers. It would have also trimmed back on the amount of reimbursements that employers had to make for H-2A employees. So without getting into all the specifics, there would have been a lesser cost for employers in transportation costs for any foreign nationals coming into the United States, as well as returning home for the United States. And because that blueprint is already established, and because I think having given you kind of the background of what the Trump administration has done and has already articulated what they want to do, I think we can look at this as a pretty good example as to what any new regulatory changes might look like. They are going to quite dramatically shift from worker protections to employer focused protections. And I don't want to use the word protections for employer necessarily because I don't think that's the way the Trump administration would frame it. But the focus will be moved from worker protections to an employer focused angles. And the passage prologue, these are the types of changes that we can certainly expect following the Trump administration's ascent to the White House in 5 days, January 20th. With that, I'll hand it over to you, Kyle.
Awesome. Thank you. Yeah. Yeah. No, what would be really nice, that the thing about the rule that Jeremy was talking about a minute ago was that was also the rule that introduced the idea of using the OEWS wage rates for determining the wage rates for occupations that were outside of the big six occupations. It would be really nice if they reverted on that because they realized it was a horrible idea. But I don't know if they will. But if you know a guy who knows a guy, then go ahead and get that message up there that rule still sucks. Okay. So there was a new rule that came down from the USCIS on modernization of the H-2 program. There's some really significant changes here. And a lot of them are actually something that we've been waiting on for a long time. That I'm gonna just kind of skip past that part, but there we go. Okay, I'm just gonna get into kind of what some of the big ones were. So one of the big ones, which has actually mattered before, was every year there's a designated country list that's released that basically informs employers about which countries they can bring people from on the H-2 program. USCIS did away with the designated country list. And so now you can technically bring people from wherever on an H-2 visa. And this has mattered a lot. I've had a lot of clients try to bring people from the Philippines, for example, on H-2A, and from India. Neither one of those I guess the Philippines were for H-2B. They were on that list, but they weren't for H-2A. And I've had a lot of clients want to bring people from India, and they weren't able to because they weren't on the eligible country list. But and so now the nice thing is that's technically possible. The one caveat here that I would tell people is just because it's on the list doesn't mean that approvals will come easy. The consulates themselves actually treat issuance of visas significantly differently. So, for example, getting an H-2A worker from Mexico or from South Africa, really not that hard. Getting one from Nicaragua has been really difficult. And so, and it's just a matter of the embassy denying the visa usually on the basis that they think that the foreign national is not going to return home after the employment. And so, while it's technically possible, I just want to give people that caveat because I want to overly rely on countries that are new to the H-2A program or the H-2B program because it's going to take some time for the consulates themselves to get comfortable with the issuance of the visas. The simplified stay of the clock reset. So every prior rule, every 3 years, the foreign national had to depart from the United States for at least 3 consecutive months. But it wasn't that easy. There was also this like scaled system for determining if they ever met their length of stay outside the United States based off if they were here for 3 years or 18 months. And it was a mess. It wasn't as clean as this. So it just says the 3-year stay clock resets after 60 days outside the United States. Really nice, really clean, and it's easier to prove. Now, this is one of the things, especially if you're an employer that transfers workers between different labor certifications. This is one of the things that we always tell people, like, hey, collect some evidence that this person departed the United States, because the port of entry is not particularly good about maintaining the departure date. And so if you get online and you pull up their departure and arrival records, the foreign nationals' departure and arrival records, a lot of times what you'll see is it'll say entered, departed, entered. Of course, it's not actually possible that you enter twice with no departures, but they don't really maintain those records well. So still do the same stuff that we always tell you to do. Worker gets home, have them go to the doctor for a checkup, send over a copy of that, just so that if you're transferring the worker in particular, that you don't have an issue as it relates to the duration of stay, and you can show that they were outside the United States for at least 60 days. Some of the big things that there are also aspects that I would say overall those things are actually kind of employer friendly. I mean, it's kind of nice that there's also something in there that's employer friendly as it relates to immigrant intent. That was one of the things that we've been looking to come down for a long time because it's helpful whenever you're filing green card filings, for example, employment-based green card filings for H-2 workers. I think that part about it is also, which we'll go into that more probably at a different time because it actually requires a lot more explanation. But those things in this role, pretty employer friendly. That there are some aspects of this rule that make me think there is a possibility that it will be challenged, because some of these not so employer friendly rules, I'm not so sure that they'll be able to stand up, but they have stricter penalties for employers charging prohibited fees or violating labor laws. I think that the part for me that makes this particular rule concerning is the burden of proof on them showing that an employer charged prohibited fees is really not very high, and then the consequences for it are really severe. And so usually whenever I see that, it doesn't take like an actual finding of the employer charging the fees or the employer knowingly charging the fees. And I've seen it before This is one of the really bad things with H-2. No one ever wants their workers to be charged for the opportunity to work on an H-2 visa. It's strictly prohibited. Uh, but it generally becomes more of a strict liability issue for employers. And I've seen it before where whenever I say employer, it is the employer or anyone acting on behalf of the employer. And so let's say that you own a company and you're bringing in H-2A visa workers. And you have this guy that's worked for you forever. He's a lawful permanent resident in the United States, but he's from Mexico. He's got a lot of family in Mexico and friends in Mexico. And you say, hey, I need to recruit 25 people to come up here and do X type of job. And they're going to make this amount. Well, sometimes what happens is that the person that you're relying on for recruitment goes to his friends in Mexico and says, hey, you're going to make $20 an hour to come here and work. And I just want you to pay me $2,000 whenever you get here because you're going to make a lot of money while you're here. And he does this for all 25 people. And employer, as an owner of company, has no idea that it happened. But this person who was acting on behalf of the employer did this thing that's directly against the law. And the workers come up here, and let's say that a DOL audit occurs, and the DOL comes in, and one of the first questions they're going to ask those workers is, were you charged fees, or were you charged anything, any kind of favor, any kind of compensation, anything, for the opportunity to come and work on an H-2A visa? Well, they might not know that they can't tell them, and they might just say, well, yeah, I paid my cousin $2,000 so that I can come work here. And what the employer can do is they can then go and then they can find the employer, as in the company, not only back wages, so the back wages being the $2,000 for 25 people or $100,000, but also civil money penalties on all those. So DOL can do all that. Employer, owner of the company, actually had no idea. I could see this being an issue with this new rule because the owner of the company themselves wasn't engaged in anything unlawful, but the implications on their company are really severe. So I don't know. We'll see how that goes. Enhanced protections for H-2A workers reporting violations. There's already a lot of protections for H-2A workers reporting violations. If you have an H-2 worker and they're reporting violations, don't retaliate against them. If they're just exercising their rights, and this was a big push actually during the Biden administration. We didn't used to see the state workforce agencies coming out every single year telling every single person how to reach them if they're disgruntled or think that the labor laws are being violated. Now we have that for the most part, where the state workforce agencies in most states will go out and actually talk to the workers as they arrive, and quote unquote inform them of their rights. Of course, frankly, state workforce agencies oftentimes misrepresent what their rights are, because they don't really know how wages are assigned and that kind of thing. But anyways, the goal of the state workforce agency is to inform the workers that they have an opportunity to reach out to them for any perceived violation of their labor laws. And there's already been rules on the books about retaliation and terminating people for that. This just strengthens it. Site inspections. Employers must cooperate with site inspections or face petition denial revocations. Basically, it just for most other types of immigration, H-1Bs, for example, USCIS can come on and do an on-site inspection to ensure that the petition was valid. Basically, the information provided was true and accurate. This just allows for USCIS to do the same. Overtly allows for them to do the same thing for H-2 petitions. Okay, so yeah, there's some there are some good, again, there are, that this was a pretty balanced rule and that there was actually a lot of good employer stuff. So the, there's a new 60-day grace period for employment on H-2 status. Historically, for H-2A, it wasn't, or H-2, it wasn't nearly that long. And this is really nice. So basically, at the end of the job, the worker has 60 days to find subsequent employment. This is more consistent with what you have with like the H-1B rule. It's actually directly consistent, I think, with the H-1B rule. And then the 60-day grace period after a revocation applies to all H-2 petitions. So if there is a site inspection and employer petitions revoked, then they would be able to find subsequent employment. And then that immediate work eligibility is nice. This is one that I think that most employers don't appreciate and maybe have violated historically. But workers can start new employment as soon as the extension petition is filed. So that's great. All right, let me check our time here because we might. All right, let's. We'll probably have to separate this into two separate webinars because I want to make sure that there is enough time for Q&A. So I'm gonna actually end my part right there. If you have questions on here, please go ahead and add them to the Q&A, and then Jeremy and I can talk about them. So the first question is, when an employee goes back to Mexico, do we in fact, or do we ask for confirmation that they are in fact back? Yeah, I would. And the reason for that is because if you're applying for them in US, I guess really what I care about more is that they're outside the United States. But yeah, you do want evidence of their arrival back in Mexico, for example, because then you can prove it if the USCIS ever asks and they're concerned about the violation of the 3-year rule, which prohibits their continuous stay for 3 years. So, and normally the issue is primarily because of the USCIS or the CBP's record collection at the border, where they just don't maintain it, and so then they put the burden of proof on you whenever you're filing some sort of USCIS application. So yeah, no, I certainly do. So generally what I recommend is that whenever your workers go back to Mexico, have them go to the doctor or something like that so that they can send you a note from the doctor that says that they were physically there. This was a question: would the H-2A freeze affect the H-2B wages? Is this webinar mainly for H-2A? It was for H-2A and H-2B because the rules affected both of them. The example that you're talking about was a specific H-2A rule. The freeze is not something that's currently in effect. And so that would, but I mean, yeah, that I guess in theory they could try to freeze the H-2B wages too, but it's that was just a separate rule. It was just for illustrative purposes.
Yeah, and if I could just weigh in a bit there. So there are different wages that are attendant to H-2A and H-2B. So H-2B is going to go generally through the prevailing wage determination process, right, which is through BLS. And they have a very sort of elaborate and orchestrated system as to arriving at wages. That system is almost certainly not going to change. It would take, I don't know how many administrations to change to go to unravel that program. There have been very tepid tries to roll back some of the prevailing wages because many people have thought that the prevailing wage determination that comes through NPWC, the National Prevailing Wage Center, are too high, that they're superficially granted higher wages based on certain areas of location or based on the job duties, and the BLS doesn't have the greatest data, and so they err on higher wages. But for H-2B, that process is kind of locked in. Now, what I was referring to in my little portion of the seminar earlier is a H-2A rule that was introduced under the Trump administration that could freeze in wages. And that's an entirely different sort of wage structure that does not go through the prevailing wage determination process. That's mostly based on an AWARE, and that's kind of that might be outside of the frame of what we need to discuss today, but that is possible. The new incoming administration could look at that and say, we need to freeze wages at a certain rate for a certain period of time, as they tried to do in that promulgated rule, which, like as I said, was this close, very, very close, but it didn't make it into the Federal Register as a publication, and so it was withdrawn by the Biden administration.
Uh, Thank you. With the 60-day grace period, if the H-2 doesn't find another job, the employer is still financially responsible for getting them back to their home country, correct? Yeah, that's right. Yeah, and you would also, yeah, yeah, that is right. You would. Uh, when the workers return on their H-2A visa, will the I-94 reflect the 60-day grace period? That's a good question. I'm not sure. I would need to re-reference the final rule to see if it actually has the grace period on the I-94. I don't think so.
No,
I
no,
think
it
it still has.
doesn't.
Yeah.
Yeah, there's gonna be the departing foreign national will leave. There is going to be, a stamp wherever the country of origin is, and then there is other indicia. That's the final rule language as to how to prove how long they've been outside of the country. And so, those can be pretty much anything. So you could look at utility records, you could look at
Oh,
bank
Jeremy,
accounts.
I think what they're talking about is the grace period that you have to find subsequent employment.
Okay. I thought they were talking about the 60-day. Okay. Yep,
Yeah.
fair enough.
Yeah. Yeah, but I still don't think that it is. I think it'll show a normal travel period, but I'm not sure. I'll need to re-reference the the final rule, which is unbelievably long. So, uh, would we have to reimburse them for going to the doctor to get a note to prove they were back in Mexico? No, you want it, and also that's just an example. They we really just need them to prove somehow through physical documentation, like what Jeremy was just talking about, utility bills, doctor's notes, anything like that, that they were physically back in their home country. And there's nothing new about that. I mean, that's that we've been doing that part for years. Okay. ACA medical benefits. Do we need to provide medical benefits to H-2 workers? Uh, yeah, there is still a requirement for to. I guess it's not nearly just like this straightforward, but I would generally yes. It's based off of the duration of say that they're here. I think I'd have to go back and look. I know I looked at this like a year and a half ago, but uh, generally yes, you would have to provide. You do have to be in compliance with ACA as it relates to H-2 workers. About new form I-129, do we know if this will be done online or if it will remain a paper application? I don't. I hadn't even thought about it being online. Maybe. Do you know that, Jeremy? That'd be awfully nice.
That would be awfully nice. So USCIS has tried to move towards more online filings. This was supposed to be because it is one of the ones that's used most abundantly from all filings. I would think that if USCIS is going to revamp the form and if they're going to put out a publication allowing that to be one of the filed forms, we would know soon. We have not received that information yet, but hopefully that's something. The problem though is that there are attendant exhibits to I-129s often, depending on which visa type is being filed for. And so while the form itself might be able to be filed digitally, the other forms likely will not be able to be filed. So um, at this point, we're gonna have to kind of wait and see. I think the safest route is just to continue as operations are normal.
Yeah, that's a good point. That's a good point. Maybe eventually they'll let us do it for the ones that don't require original documents. That'd be great. Uh, any projection on whether H-2B caps will increase under the new administration or any major reforms regarding the H-2B process? We don't really have that information right now, although I will say that the cap itself, I would not expect to increase because the cap itself is statutory. And that, yeah, as Jeremy was saying a few minutes ago, thinking that we get immigration reform from a legislative perspective is pretty wishful thinking. It just it's a political football that's more convenient to not fix than it is to fix. And but now, as it relates to supplemental visas, which are the northern Central America countries, and then returning workers, which is anyone that's had an H-2B visa in one of the last 3 fiscal years. I would expect them to continue the policy to issue those as they did their first administration. The only thing that we can do is kind of look at history, and especially as it relates to something as nuanced as the H-2B visa. And then during the Trump administration, they did provide for supplemental visas under the H-2B program, except for in 2020, although they were in the budget bill in 2020. They just didn't end up issuing them because unemployment rates were like 30 or 40% or something. So, all right, cool. Well, we did it. We are officially past the 11 o'clock Central Time hour. And I appreciate everyone joining. Jeremy, thank you so much, man. It was great to have you on here. And then, yeah, we'll talk to everyone soon. Thank you all.
Yeah, thank you all so much, Kyle. Thank you, and Omar for putting this together. I hope yes, he's with us. Thank you both. This was fun. Let's do it again.
Yes, sir. All right. Thanks, y'all. Bye.